Thank you everyone for joining us this morning. It's wonderful to have so many attendees and to see the response. Just to do a bit of housekeeping this morning and explain who's who and what we are going to be doing. Your cameras and microphones have been muted. There is a Q&A that should be open to you. If you have questions that you would like to pose to any of our participants or panelists, please do so. As they arise, we will try to deal with them at an appropriate time, or if we don't get to them, we'll also try and deal with them at. Unfortunately, our time is very limited and it's quite a broad topic. So we are going to move.
Oh, we lost Justine.
So just to also, sorry, to manage expectations as well. Mignon is currently to leave a little bit. Obviously, that is primary for her at this stage because it's hell of important for her to be there to support the individuals who are participating in that process. So if you see her leaving or sneaking out, that's where she's going. It's not that you're boring her. And so we ask you just to work with us in that regard. Okay, so let us start with who's who and to introduce our two panelists who we are extremely grateful to have joining us today because they are very busy women but going to be so important to our discussion, very well qualified, knowledgeable and experienced. So first of all, to introduce Mignon, seeing as I've singled her out already. Mignon is a psychologist with dual registration in the categories of clinical and neuropsychology. She has 25 years experience in clinical practice and her practice currently is split 50-50 between psychotherapy and neuropsychology. She also serves as an expert witness in personal injury matters, in addition to teaching postgraduate students at UCT, and she also taught previously at the University of Stellenbosch. And Mignon truly loves her job. And I can attest to, based on my interactions with her, that she really does. And she's incredibly passionate about the topic. So we're very grateful to have her joining us today. Thank you very much, Mignon. Then Elise. Elise I've known for years. And Elise has an occupational therapy degree from UCT. She has a certificate of proficiency in life assurance. She has a certificate of law from UNISA. She is a certified mediator through UCT Mediation in Motion. She has held claims management positions with 3 international reinsurance companies in South Africa and was one of the founding directors of Illyrius Holdings-backed company before she decided to go into consulting. She's responsible for the first ever SA University certified expert witness training course for health professionals, which is run in conjunction with UCT Health Services, the UCT Health Services faculty, as well as a practical and legal claims management training course run under UCT Law at Work. So that is who we have today to speak to. Important for Arjun as well is the services that Elise offers and why she is such a valuable participant today is that she, amongst the services, are medico and legal expert assessments and reports in litigation matters, employment functional capacity evaluations, and independent expert opinions in disability, incapacity, and ill health matters. So those are our two panelists, and thank you very much once again for making the time to join and to assist us in educating everyone. Just a little bit about why are we having the webinar and who I am. For those who don't know me, I am an attorney in Cape Town specializing in employment law. Our practice advises both employees and employers, and we've seen a distinct increase in clients seeking advice with regards to capacity issues in the workplace. And in addition to that increase with regards to capacity issues, and when I say capacity issues, not just physical, that we're more used to dealing with, but also we're seeing an increase in psychological, mental health related queries. And in addition to that being quite I think practically very complex issue, it served in highlighting to us gaps in the understanding of the incapacity investigation in terms of Schedule 8 of the Labour Relations Act, and also just practical compliance with Schedule 8. So that is why we're here today, because we've been seeing an increase in queries with regards to mental health and psychological related matters, but also this gap. And we're seeing employers and employees involved in processes which are kind of named two things for easier reference: a cookie cutter approach on the one side and a silo approach on the other side. And the cookie cutter approach is, this is how we've dealt with it in the past, this is how we're going to continue dealing with it regardless of the individual involved or what is involved. Or, and often we're seeing this is where we start the performance, the individual says, but hang on, the reason why I'm not performing, the reason why I've committed what you deem as conduct is because of some sort of ill health issue. And well, no, it's in response to something that we've already started, misconduct, capacity. So we're continuing with that process because that's what we started with and that's what we know, and we don't deviate. So that's the cookie cutter approach. The silo approach that we're all seeing is there's no holistic approach to the incapacity investigation or situation. So everything is dealt separately. So we're dealing with looking at the workplace and what's the person doing wrong or doing right or what they can do. Then we're dealing with if there is a group life assurance or group life policy or something like that, that's separate. Often I'm misunderstood, and often employers we're finding don't know that they can claim under that policy, and that the policy is actually their policy and not the employee's policy, and where the responsibility lies with that. And then the treating physicians are completely out of the picture. So that's the silo approach, dealing with everything independently, realistically. That's what we've been experiencing. And obviously it caused us to ask a number of questions, and we thought our audience may have those same questions, which is why we have us today in their areas and fit into holistic, I think should be adopted. And thank you. And it's why we're here to kind of educate, if we can, what is possible, what isn't possible, what you should be asking, what you shouldn't be asking, and how you should be dealing with it more effectively. Thank you. I've given you a long mouthful, but is there anything that either of you would like to add at this stage?
No, I don't think so. Thank you.
Please. All right. So let's the approach is we start
Is just on my side, or is Justine's sound breaking up quite a bit?
Justine is frozen for a little bit.
Is there a problem with my connection?
You're back now.
Yes.
Okay. All right. Let's start right at the beginning. But I have a number of questions. I'm the attorney. Shall I just act? I'm going to ask you questions based on what my clients are asking me, if that would be of assistance, and I'm a bit skeptical as well. So the first question I often get from HR when I'm advising clients is the medical practitioner who's treating this individual, particularly when it comes to mental health issues. Why should I believe them in what they are saying, because they're going to do everything that they need to do to protect their client or their patient. They're there to safeguard the patient. They're not, and to protect their employment at all costs. Why should I take what they say as being truthful? Mignon
Can I
or
perhaps
Elise? Yes.
Can I come in there and say that as a mental health practitioner, one's objective, your key objective, is to improve an individual's adaptability in the world, be it in the workplace or in their psychosocial world. So one would be failing if one was just predictive and taking the client's subjective version of events at face value. So your main purpose is to take that subjective crystallized perception and loosen it a bit and open it so that there is a broader capacity in the client to evolve from perspectives as well. And that's the therapy process. When one feels protective of a client, it is typically when the client is really not able to manage at that particular time. It is not a decision. So giving, let's say, for argument's sake, a medical certificate based on mental health issues is not a decision we make easily, because it is always met with some skepticism. We all know that. So one would be very convinced of your case, I would say, when you book a client off for mental health reasons. You're also hesitant to do it because you know that mental health issues in the workplace are often frowned upon, often discriminated against. So yes, one might feel protective of one's client because you see their distress, but you're not just thinking, I'm going to make sure that he or she has a week at home or 2 months at home. You are thinking of the repercussions of the employer now being aware of a vulnerability. So it is a difficult decision that is made carefully and with great consideration. And we've got very particular guardrails. It is not just an impression after one session. It is a very carefully considered diagnostic process using a diagnostic toolkit that is standardized internationally, and one operates within your ethical code and, of course, your reputation. So no mental health practitioner wants to be known as that psychologist or that psychiatrist who books everyone off. That would immediately ruin your reputation. So it is a difficult decision for a practitioner to make, and it is a very carefully considered one. And ultimately, one's goal is to get the client back into life as fast as possible, because that would be therapeutic success. Pulling someone out of their life, out of their work, that is a temporary holding bay that you only use when it's essential. And I want to just conclude by saying our ultimate goal is to increase adaptability and resilience and ability and functionality. All of those things are or imply that person can go back to work as quickly as possible.
Thank you. Thanks so much. Elise, is there anything that you want to add to that?
So I think when HR or employers are faced with information, which may be seen as subjective. I mean, Mignon's placed that extremely well from a professional perspective. Obviously, reputation and objectivity and doing the right thing is what the practitioner tries to do. But if human resources or management, says, oh, well, I'm not sure, there's no reason why the conversation can't unfold between the HR practitioner and the medical professional, obviously taking confidentiality and things into account, because a lot of stuff can't be disclosed, or with the individual concerned, or to get an independent person involved to say, look, I've got this information. This is what my employee says. This is what the medical evidence is saying. Where do I go from here? How do I manage this? Do I send somebody out to chat to my employee? Do I get another opinion? What should I actually do? So that's not as if that's the beginning and the end of it. They're getting this information from a treating practitioner. There are ways to interrogate that are very professional, careful, sensitive, compassionate ways to actually get more information about how to take the matter forward and what to do with it.
Okay. So what I've often also heard, thank you, Elise. But just putting forward what I'm experiencing with my clients, I'm dealing with the employers, but obviously we have employees as well. And I would like to ask you a couple of questions based on their experiences as well. But just sticking with the employers for the time being, is that I've seen, and as with everything, yes, we're all human and everyone does things in a certain way. So please, it's not a generalization. But I have seen when HR has tried to engage with medical practitioners and they get letters back, which are quite aggressive and contain large sections quoted from the labor laws and Employment Equity Act and all of those things, which as an employment lawyer often are not accurate or correct. But that is, and I'm not saying once again, and to not everyone, but I've seen a number of these letters. And how does that then translate with the HR person who's now, I'm reaching out or wanting to ask this information and I get this back?
Can I make a suggestion? And perhaps I'm speaking most specifically about mental health practitioners.
Yes.
As HR, if you have an employee flagging that they are not coping and you can see the wheels are coming off, to form a collaboration with them and say to them, I want to best support you. Would it be okay for you if we pull in your treatment team and do that, because that can guide me? And it's a way of opening the door, because you can only get to speak to those mental health practitioners if the client gives consent. So you've got to make it, this is about handling the situation wisely, and do you give me consent? And what I've seen works well is that the client then writes an email to HR, to their therapist, to their psychiatrist, and connects everybody with a little email consenting.
Mm-hmm.
And that might be because you will not get information as HR, you will not get information unless the client has bought into it.
Sure. So, and that
And
would
I think
be
it's immensely helpful to work with HR in situations of successful work integration. I've had the opportunity to work closely with HR, and that can be a beautiful process.
okay.
Yeah.
And it
Yes,
is,
it
Minion,
is.
you're absolutely right. If you can get everybody to work together, which is it's the first prize, absolutely. But sometimes there isn't an HR, or sometimes there's a bit of pushback or reticence for further, discussion or collaboration. And my experience where I get called in, to put it that way, is as an independent, because as an independent health professional who has an understanding of work environments, incapacity, the relationship between the two, plus obviously what labor law, our understanding of the context, is that independence makes everyone more comfortable, because that one's got the capacity to pull in the bits of different information from the different people concerned in a way that it can all weave together and help HR or the management, if there isn't an HR department as such, to understand what's going on and make a plan for the future.
Okay. So as I understand it, what we're suggesting is a far more collaborative approach, not those silos, the
Yes.
silo effect. Okay. And that would be welcomed, I would imagine, from professionals, to at least the treating physicians, to be given some sort of direction as to what's happening and being able to contact HR directly because the patient, particularly when it comes to mental health issues, may also not be able to facilitate it beyond just sending an email and saying, yes, I give consent to speak to my treating physician. Depending on what they've been diagnosed with, what they're experiencing, that process in itself could create huge anxiety and difficulty, I would imagine.
Something that I would say in relation to your observation is that when people suffer from a psychiatric disorder, they are often having difficulty processing information in a logical, rational fashion. And their HR can lean on treating physicians or treating mental health practitioners to help the patient metabolize feedback, process ways of thinking around problem solving and going forward. So a case that I'm involved with now, I've asked if I can be the first to sort of pave the way with giving the independent assessors feedback, because I know if I can lay that foundation, the blow is easier, the consequences will be digested more easily.
Wow, that's very useful. Elise, anything on that you'd like to add?
Oh, that's very helpful, and that's where. So if one has an independent opinion about how to bring the employer-employee back together, it is fantastic if you can work, like Mignon's example now, where you can work with the treating practitioner, or let the treating practitioner actually help bring that together by breaking the news or sharing the information. It is because it's not the employer that's doing it, and the person feels safe in getting that information and being able to test it out without running the risk of, well, should I ask that question, or what will my employer think if I say this, or if I ask that, will they think X, Y, and Z? So that's a lovely example of the way Mignon has explained it.
Okay. And I mean, at the end of the day, that is what Schedule 8 of the Code of Good Practice is really aimed at, it being able to rehabilitate and return the individual to working. And only if that's not possible, after alternatives have been explored, to look at terminating employment potentially. So that would be part of the process that an employer would be required to follow. Often we see from the employee's perspective now, turning on my hat for employees and representing them, is it's often just a tick box exercise, right? We've done this, I've looked at this operationally, okay, this isn't going to work. Maybe we can't afford to have someone who's going to be around because it's a mental health issue, for example. You know, these things take forever to be resolved. We don't know what it's going to be. And that's it. And then it becomes a tick box exercise rather than actually trying to reintegrate that person or to see what is possible to assist them. That's from the legal side of things, that what is required. So what you're suggesting is to work together to see whether we can reintroduce them. And I would imagine the quicker one starts that process and the more collaborative it is, the quicker the rehabilitation potentially, depending on what the condition is. Would that be a fair comment?
Yes, and I think that, and I'm sure HR who are attending will smile when I say this, that these situations are so complex because you've got a psychiatric illness that unfolds, but as part and parcel of that, and that is seated in the individual, but it's also relational. And by the time someone is diagnosed with this psychiatric illness, there's already been relationships in the workplace. There's already been deterioration in work performance. So the dynamics in the workplace have become scratchy and edgy and difficult. There's a breakdown of connectedness for everybody, not just the individual who's not well. And to navigate that territory takes time and skill. And I like what Elise says, having an external mediator to help all sides understand what their emotions are they bring into the situation, their biases, their fears, their judgments, their disappointments and anger, and for both space to vent and be heard and then find steps forward. Difficult, the steps forward, because it always requires compromise on both sides. It's like marriage counseling.
I like that. Can I pick up on the compromise on both sides? So, because just as you were saying that, I had to smile because something you said about a tick box, Justine. My experience has been, and funnily enough, working with big organizations, even in the same environment, has been, let's work on how we can actually adjust the work tasks and the outputs and the time that people get back to reintegrate versus in the same organization versus we don't have a way of accommodating this person. We just don't. And so you can get a very different approach depending on management and their ability to engage with things like incremental step up in hours, job swapping, sharing aspects of a job and outputs, being able to ergonomically change an environment. And I shared with you when we were chatting before, you know, how I had a case many years ago where the particular environment had particular ways in which people worked with particular branding, and the individual concerned needed their own desk and ergonomic changes in a special office environment due to tetraplegia, partial tetraplegia in the upper limbs. And my response, the response I got was, we can't employ this person because if they can't work on the floor in the actual office environment as it is with the branding and everything, they can't be employed. That was the original approach. But once we worked together, we ended up with a very, very happy compromise, to use Mignon's term, in that we found an office, we adjusted the workspace, the person could continue working, there was accommodation, and everybody ended up happy. But that would not have happened without bringing the parties together to talk about how this could be adjusted. It wasn't a matter of planting the person back in the workplace as it was. It was a matter of adjusting the workplace and the outputs and the way work got done so that everybody could carry on and keep the value in the relationship.
Right. And I mean, it sounds, as wearing my hat from an employer's perspective, then and often asked, it sounds like a hell of a lot of work for the employer to do when it's not their problem, right? So,
and can I add, it's a hell of a lot of work to do when it's not your problem with someone who is not responding in an easy way. Because once you get to that point, you are dealing with a person who's reactive, fragile, complicated to read, confused. I take my hat off to HR for how they sometimes manage these things, because it's very difficult.
So speaking to that, I mean, the return on investment, there must be some return on investment, right, for business and HR. Well, HR being the face of the business often, to invest time in it, aside from the legal requirements, which are there to protect not to protect employees, to ensure that there's fair treatment on both sides. Because there is a compromise that the law reaches as well in situations like this. The employer is not expected to accommodate the individual unreasonably, and depending on whether the individual is disabled in terms of the definition of disability in the Employment Equity Act, if it's going to cause them an unjustifiable hardship, then that accommodation they don't need to accommodate in that sense. So there is a middle ground for both parties. The question I have, and HR often has, particularly when it comes to mental health, because that is unique to everybody. It's not, once again, that cookie cutter approach. Just because this person who is suffering from depression has taken a month to be able to get to a point where they are comfortable returning in whatever capacity versus someone else who's got depression is going to take longer. That seems to also be a cookie cutter approach that we are seeing. But with physical injury or illness that's visible, employers seem to be able to deal with that more easily because it's something that they can see, and there's a timeline to what they can do. You know, if you've got a broken limb, we know statistically it's going to be knitted within so long, so we know we need to accommodate it, and it's something tangible that we can see. Whereas with mental health, it is very individual. In my experience, dealing with different situations, and often the employers who I deal with were like, well, you know, how long do we have to accommodate this individual? Yes, we want to try and we want to do what we need to do, either because we're committed just to the legal side of things and making it work, or because we have got additional moral and ethical, social considerations that we want to involve. But how long is that? And do we have something to work towards? Because I think one of the things is when it comes to mental health, that there's no end point that we can work towards. If there was something that we could work towards, it may be more palatable. Okay, we can see the light at the end of the tunnel, so to speak. Is there a way? And how does that work in practice when the independent individual, well, someone like Elise is giving the independent opinions, having spoken to you, having presented a plan? How does that all fit into it, and what can the employer expect?
So I think all incapacities, mental and physical, I mean, there is a recovery time and a reasonable expectation to go back to work in some cases. There isn't in others. I mean, one's got to be quite clear on that. So if we take a situation of whatever incapacity, and there does look like there can be an accommodation, then it's a matter of setting up a return to work process, which generally we recommend as occupational therapists a case management process of actually helping both employer and employee get back into the work situation over whatever period of time. And there are there's a program, there's certain outputs, requirements, there's a timeline attached, which might need to be tweaked and adapted as we go along. So let's say that's 6 months or it's a year. But right at the start of that process, there needs to be an understanding that if this really doesn't work with all the effort from everybody, then it doesn't work, and there's an outcome to that, which could be it could be going on to a claim through the group life for the group disability cover, or it could be termination. But one's got to be realistic about what is possible to start off with, have a realistic plan which might to be tweaked, and then work with that. And in most situations, it does end up in a happy situation of being able to make it work. But in some situations, it doesn't. But everybody understands that from the beginning, that this is not a shock to anybody at the end of the day, because there are situations where it doesn't work. There are also incapacities that are actually, of such severity that the person is not going to be able to go back to that particular work environment. And as unfortunate as that is, the employer can't create a space that's going to uniquely accommodate someone where it doesn't fit with the work environment, the work environment and the outputs and what they're doing as a business. I don't know if that helps.
It does help. Thank you. Mignon?
I think it is a complicated sweet spot to find. How long is a piece of string? And as you were speaking, I was trying to imagine some of my therapy clients who I am in a process like this with. And if I'm asked, when will the client be ready to go back to work? Which is always the goal, because going back to work means your income is secure, you've got a purpose in your day, you are functional again. So for me, the goal was always as fast as we can. But my dilemma sometimes is that I think of the work environment, the actual work demands that may be particularly stressful, and then the interpersonal dynamics that there might be individuals, teams, human factors that add to the stress. On the other side, for the client, job insecurity and financial insecurity is a stress. So there are stresses bookending the client's mental health crisis. And it is very difficult to navigate that with a client. From a prognosis point of view, which I know is what HR desperately needs to know because they've got to get on with business, I do think that as clinicians, we can make an estimate. As part of the medico-legal work also, one has to comment on probable prognosis. And if specific treatments are in place, and I think one needs to, as HR, you are allowed to have an expectation that the employee does what is needed, complies with treatment, so that everybody works towards that improved place in functioning. But as a clinician, one can say, given the severity of the psychiatric illness, given the pre-existing vulnerabilities, the course of this particular illness, the factors that feed into it, one can reasonably estimate how long it will take. Maybe not as accurately as an orthopedic surgeon who can say a bone will knit in 6 weeks, but a soul can also knit. And if it cannot, as a clinician, one begins to get a sense of that. And then one does steer the client in a direction of, okay, so this is not going to work. Do you agree? And start working towards an alternative life course.
And that sounds, what you're saying there seems to be of value as well for HR practitioners and employees facing a situation like this to understand is that, and as Elise also said, sometimes it doesn't work because the reality is that the person is incapacitated to a stage where they cannot be accommodated. But it sounds to me as though with you, particularly with mental health issues, where you're involved or someone else is involved, you are assisting that individual to come to terms with the fact that their employment is going to be ending. And if it's done in conjunction with HR, then it's going to be an easier course, so to speak, to bring it to an end because the individual understands and has reached a place where they understand it. And you're assisting them moving on and seeing what else there is potentially for them.
Yes.
Okay.
As a practical example, I've been involved in a process with a patient who has a long-standing history of bipolar mood disorder and some personality dynamics. And she works for an employer who is particularly mindful of any kind of neurodiversity or mental health issue. And HR invited me into several meetings where we worked out an accommodation plan together, kept feeding back to me. I, in therapy, could sort of keep reinforcing it. And we even had a session of education and sensitization for colleagues who by then were, of course, already very disenchanted with my patient because things were not easy in the office. So it was a very successful process of getting the person to work and continue being productive, but with accommodations made. So
And
that was an ideal story.
that's a lovely story, and highlights a very important aspect of the team. So when somebody is seen to be treated differently or specially, or because of accommodation of some kind of incapacity, mental or otherwise, there can be a negative pushback from the team. And so there, one ideally likes to do the kind of thing that Mignon's just mentioned, a desensitization kind of workshop, an explanation workshop, education, without breaking any confidentialities, but enable the team to understand why person X has been accommodated in a certain way. And that this is not because it's not because they can't have that accommodation, but that they've somehow been treated lesser than or something. It's really just the way the circumstances are, and it's a way that everybody can work together in going forward and keeping skills on board. And that sometimes can be almost a bigger issue for the person going back to work than the actual going back to work, because there might be a bit of this resistance from their team members.
Yeah.
I think there's the person with the difficulties feel possibly lesser than and exposed and judged. But then when accommodations are made, of course, there's always the risk that team members feel envious. And
envious is a better word, yes.
Yeah,
yes.
envious and scratchy about it.
Absolutely. And we all we're dealing with humans, right? With everything. The law is beautiful as it's written, and if it was applied in a pristine environment and there weren't human emotions and all of those things, it would be fantastic. None of us would, I definitely wouldn't have a job. But we're dealing with human beings and we're dealing with business, and it's messy, right? So it's really just it sounds like to collaborate, make sure that you have the right people on board, make sure from an HR perspective that we know what we need to do from a legal perspective, but also know that it's a holistic approach that should be adopted, and that you can trust whoever's treating the individual to be professional, because that is what their job is. It's the same as with us. If you come to me for legal advice, you're going to get objective advice, because that's my job, but B, it's these ethical considerations and professional considerations and reputation. The same applies. But the outcome is going to be so much better if everyone works together. And I think something that I find incredibly useful from just this brief chat is that it is welcomed. The questions and the collaboration from HR or from the employer or whoever it is, because not everyone has an HR department to assist them. That approach to, can we work together? Can you explain to me what's actually going on? That is welcomed on behalf of the employee, and that if the organization, for whatever reason, are still skeptical, that there is the option of bringing in someone to give an independent opinion, having spoken to everyone, pulled all the information together, and who can give an independent opinion, but also assist in putting together a plan that can be followed by everyone. So I found that incredibly useful. Sorry. And then what I also found useful from the discussion, I know clients of mine will find it useful too, is that they can have an expectation that the patient or employee is also required to do certain things, because there's kind of an idea out there that it's now it's my responsibility as an employer to accommodate, but nothing's happening on the other side, and that there are certain responsibilities as well from the employee. Obviously, those are dependent on what their treatment plan is and all of that, but that is to be a compliant patient and to follow the advice of their doctors.
Absolutely. So I think
it's got to be reasonable.
It's absolutely. And what is also helpful for an employee is when you know that there's a long period of sick leave, time off work, is to know all the facts. This is how we're going to manage it. These are the kind of interactions we would like to set up and put in place, the collaborative approach. And then if this is we are willing to work with you up to whatever is reasonable, whatever the reasonable point is. And then also, if I can touch on the group life thing, if
Yes,
there
I
is
want to get to that. Yeah.
if there is a policy in place for all the players involved to understand what that is, what the definitions are, how it works, what the expectation of the life office is in terms of how this thing gets assessed, because that is the next potential area of problem is for
Problem.
people.
Yes.
People don't
Problem.
understand that process. Yes.
Oh, problem and assistance, right? Because that
Yes.
could be of huge assistance and value to both the employee and the employer.
Absolutely.
And if we could touch on that next, we've got a couple of minutes before we move into our Q&A section. But what I'd like to understand, or for you to explain to us, is the group life scenario, because often we have employees come to us who've got this in their employment contract, they're contributing, and we're saying, okay, but why is there no claim under this? And they're saying, well, what do you mean? This is for my life. It's not, it's if something happens to me, it's not if I'm still in employment or whatever. This, not understanding what that policy is or what they're actually contributing to. But also we do experience it from employers that they don't know when managing this, even what that policy is. So sometimes someone will come to us and say, listen, I've got this situation. How do I deal with this employee? This is it. It looks like we're not going to be able to be starting this incapacity investigation. It's not going well. It looks like maybe. And then the question is, okay, but do you have group life? Is there some sort of insurance? And they look at, and the client has no idea what we're asking about, and then says, okay, we'll go and find out. And yes, we actually do. So it's not to say that all employers don't know what they're doing and everything. As you've often said, Elise, you don't know what you don't know. So that, if you could maybe just touch on that a little bit as to what it is, who the policy holder is, and where that responsibility lies with the policy as the policy holder. And then also, and this is the second subsection of that, is that the idea sometimes is, okay, well, now the claim's in process, claims being paid out, that's it. We remove the employee is no longer our problem, they must come off our payroll, they come off our books, done and dusted. And to explain that process, once a claim is being paid out, what employers and employees need to be mindful about.
So I think we're starting at the beginning. I mean, obviously
Yes.
it's a group contract, so it's part of the employment package, so to speak. So generally an employee will pay a portion towards it, sometimes not, but generally they do. And there are a number of different products out there. So let's look at incapacity and disability in very broad terms. So it'd be something called a lump sum policy that's got certain terms and definitions that people have to meet. And then there's an income benefit, which is the one which is preferable in the sense that you can have an income for a period of time until you get back to work. And there are variations of how you can maybe grade that in terms of the benefit, which is quite technical, so we won't go into. But there, it's owned by the employer. So really, when I say there needs to be, the employer needs to understand and the employee the whole context of how their incapacity is going to be managed. And it's really the employer who's got to put that in, that get that process going. The employee can't. They don't own the contract. It's owned by the employer. There's no direct relationship between employee and life office. The relationship's employer and life office. And there are things like waiting periods. There's terms and definitions around the way the incapacity is defined and needs to be assessed by the life office. And then to go to both of your points, I think, is that there's also a reasonable expectation by the life office that people will go for proper treatment and try and mitigate their own, the losses in terms of employability. So then that process then gets managed generally through HR. If there isn't HR, through a broker. Somebody needs to pool all the information together, in order to submit it to the life office. And sometimes that falls apart because there's some confidentiality sometimes between the doctor sending it directly to the life office rather than to the life assured or the employee, or to send to HR. And then but somebody's got to make sure that whoever's communicating and however they're communicating all happens in a way that it lands on an assessor's desk as a comprehensive package so they can start the process. Once a claim is admitted and paid, it's very important, well, on the income benefits, it's very important to understand how those definitions of disability work, because it's not a pension, it's not necessarily forever, it's almost never forever. It's a period of time. There's a definition around own occupation period, and then that changes generally after 24 months. Some products, it's 12 months. Where it goes into a different kind of assessment process, where people are looked at in a much broader sense. It's not just being able to work in your own occupation, it's looking at an alternative occupation, a reasonable alternative occupation that you either trained for or could become trained for. It's a much broader definition, and often benefits change at that time. So there's quite a lot that needs to be understood going into that process, and how it's all managed once it's in play. In terms of once a benefit is being paid, every contract has got rules or around how it gets paid, either through the employer or directly, and when it can terminate. So one's got to look at what the contract actually says. Does it terminate? If it's in payment and the employer terminates the employment relationship, some continue, sometimes they're bound together. So one's just got to be very careful and understand that in the context of the employment relationship and the contract that the employer has with the life office. So there's quite a lot of technical information that goes around these claims, which is really the shortest answer, is understand those and then work accordingly.
But I also add something. I sometimes wish that clients know upfront whether a policy like that exists. And I'm surprised that people assume they do, don't even know it exists, don't have anything, but they're not warned up front. So HR could play a valuable role in educating employees about whether the company does take this on or not, and whether it's their own responsibility, because that also shapes sometimes how people navigate this time in their life.
Yeah,
Absolutely.
absolutely. And I think in something we've experienced is that the policy is to the benefit of the employer, because the employer is the insured, correct? In simple terms, if you look at it, it's really for the employer, because the employer gets paid out if the employee can no longer work and they're now having to pay an employee for someone who's legally not able to work and they're required to still look after them because they haven't terminated the employment relationship. So it's insurance for them for that situation. That insurance that gets paid to them, though, gets paid on to the employee in very simplistic terms. So when the employer is says, no, well, that's yes, we've got this group life, it's your responsibility, employee, to go and deal with it. You happy, there it is, you go and submit your claim. If you do it and you get it, great, there's money for you. If not, well, it's not our problem because we've got it in place. You need to go and you need to make it happen. And we sometimes see that, not always. I mean, there are great employers who know what's going on and are, as you said, there are some that are very compliant and want to assist and all of that, but there are employers who don't, either because they just don't want to and couldn't care less, or because they genuinely don't know and don't understand that process and what it's for. And for us representing employees now on this side, it's incredibly important that the employer understands that when you have an individual who is going to be claiming or is at a stage where they need to be claiming, depending on what they are claiming for and why they're claiming, they may not be in a position to actually do all the paperwork and manage the process and interact with the broker and do all of that is now being placed on them to do. So yes, I understand that in my basic understanding of how the policies and processes work, and at least correct me if I'm wrong, but the employer needs to initiate that claim because it's their policy and they are the beneficiary. Then they need to provide a whole lot of information to support the claim, which only the employee can provide because they need to give consent. It's the same as with Mignon discussing anything with the employee as well. The consent needs to be given. And the employee needs to make themselves available to be assessed and all of those things. So that's the employee's participation in it. But to expect them now to coordinate everything and understand that they need to do this and dump it on them, as opposed to managing a process where you are the beneficiary technically of the policy and the owner of the policy, and the individual may not be capable of doing that depending on where they are and their health status. It seems self-defeating almost within this whole process.
So somebody's definitely got to pull it together. Once it's in process and there's maybe some direct relationship with the employee, somebody, please, Mr. So-and-so, go for this assessment, whatever, which usually the employer is copied on anyway. That's a different story. But certainly at the beginning, only the employer can do the notification. And there is a thing called a notification period, which is pretty critical. So if an HR department is aware that employee X is going to be off for 6 months and they have a 1 month waiting period, that should trigger straight away. They need to notify their life office that they've got a claim coming. And during that 1 month, they can help the employee collate and collect information. They also have to submit information. It's not just the employee's statement. There's an employee statement, there's medical evidence, and there's a basic pack that needs to go in. And then in their life office, the assessor will determine whether he or she wants more information and what the nature of that is going to be. Often it's an independent assessment. Often it's just calling for more information about the job description. It's up to the assessor to decide. And that usually would go back via employer initially to the employee, and then, as I say, sometime in the process it might be direct contact with the employee because they need an action of some kind needs to happen from their side. But yes, it's absolutely got to start in the employment environment.
Okay.
And my experience, no disrespect to anyone, because some of these contracts can be quite complicated. My experience in a matter a couple of years ago, working with a manager asked me to work with a particular employee who was very valuable, and I needed to engage with HR. They didn't understand their contract at all. No disrespect, because they, as I say, they can be complicated, but they didn't understand the contract at all. They didn't know where it kicked in, how it worked, what the loss of earnings formula or option was, how we could actually work with this employee during a period of ill health while she still wanted to actually work part-time. There was no, and nobody had taught them or explained it to them. And I was the first one, which was sort of, upside down because, I don't know the contract.
Yeah. But I mean, it sounds like we HR bashing.
No, not at all.
No, I'm not saying you, all of us, because we're saying the employer should be doing that or this. But it's not. It really is just what we're experiencing in practice. And once again, you don't know what you don't know. I think that's really the message. And that's why we're here to kind of help and educate and say, okay, at least if something like this happens, maybe you should be looking at this, or alarm bells, I should be doing this, or whatever the case may be. But as wearing your assessor hat, just for a very brief minute at least, if I am the employer and I'm assisting the employee, or I'm an employee who is now in a disability or in an application process, what should I be looking at? And I understand each policy is different and they may require different things and what it is. But if you could give just off the top of your head, what top tips would you give to make sure that you've got the best chance of having that claim processed smoothly and quickly? If you received a pack on your desk as an assessor, what would you love for people to know to make it easier for that assessor?
So in these occupational disability contracts, so there are a number of different contracts. I'm only dealing with occupational disability contracts because there's a whole lot of other functional impairment, critical illness, a whole lot of other ones that can also be part of the group life product. And benefits that people take out for their employees. But if you're looking at occupational disability, obviously one needs to know what the definition is of disability, because that's pretty primary. And then you would need an employer statement, an employee statement. Generally, these are forms that one fills out, a statement or a form completed by the treating medical practitioner, and then a job description. That's the very basic pack to start off with, that an assessor can't really move. Without those three things, the employer, employee, and medical, they can't start anything. Job description is very helpful, it's not absolutely primary, but it's very helpful. And then the assessor, or if I was assessing, it can look at it and go, okay, this is what I'm looking at. I have questions in these areas. And sometimes they may be job related and sometimes they're medically related, often medically related. And often at that point, a claims assessor will say, I want an independent from a psychiatrist or a physician or an ortho or an occupational therapist, so that I can actually look at how we're going to progress with this claim over the next 6, 12, 18 months. So that's where the starting point is. And it's really helpful to the assessor to have all of that basic stuff up front without having, getting one here and then 2 weeks later another one. It's just get it all together and make the life of the assessor smoother and easier by actually helping them assess the thing properly.
Help the assessor to help you, right?
Yes, yeah.
So is there a period that employees should be aware of that they need to get all of that stuff together from the side of the things that they can submit, that they're in control of? So, for example, getting doctors' reports, going to see the independent for the independent opinion. Is there a time period that should be observed, or can I do it whenever I feel well enough to do it, or whenever the mood takes me?
So there's 2 time periods. The first is the notification period. So that the employer, it's specific it's in most contracts, it sets it out. So if the employer knows that employee X is going to be off for 6 months and it's going to trigger a claim or claim application, they need to notify their life office that a claim is coming. Then there's a waiting period, generally 1 month, 3 months, depending on the contract. It can even be 6 months, but it's normally lump sum contract. But let's go with an average of 3 months. And what you want to have is all the information on the assessor's desk by the end of the waiting period at the latest. Clearly, you don't want to wait till after the waiting period, because after the waiting period, the claim should be kicking in if it's a valid claim. So you would like to help the process by making sure all that information is on the assessor's desk within the waiting period or as close to the end of the waiting period as possible. So that there's a seamless transition from maybe a period of being paid by the employer or a period of sick leave or a period of unpaid leave or whatever it is from terms of a payment point of view, so that the claim, if it's valid, can be paid. So yes, there are quite. I mean, these are all in the contract, and they're there for a reason, and they're there to make the whole process seamless and simple for everybody. But they get missed on occasion.
Well, that's what I would like to know, because I'm thinking of an employee potentially who doesn't have the wherewithal at that stage to get to do all of these things that are required of them with regards to reporting and getting documents together and medical reports and all of that. What happens if they miss that deadline, or if they don't submit within the required period? I mean, is the claim, I would imagine, if that's what the contract says, if I miss it, then my claim's not going to be accepted?
Okay, so I won't answer on behalf of life companies, but if the notification period is missed and in information isn't all received, they generally contractually they have a right not to take it any further. Having said that, there also has to be an understanding of why a notification period and submission of documentation might have been missed. So let's take a very simple example. an employee was in a coma, they couldn't actually do anything. So they missed and everything got delayed. That's a reasonable explanation. Somebody who maybe cognitively maybe had a brain injury, that cognitively couldn't get it all together might be another. But sort of just kind of not getting it together because they didn't know, or the employer was lazy or whatever the reasons, that might meet with a bit of resistance from the life office, because there are it is a contract, there is performance on both sides, it's not just a one-sided thing. So it can be problematic. So one does want to know what the terms are and try and stick within those.
Yeah. So then from an employee's perspective, if you're in a situation where it looks like you are not going to be able to work for a lengthy period of time, first thing is to get your medical, your doctor, whoever you're seeing, or your psychologist or psychiatrist or whoever, to communicate that clearly to the employer. And then to start asking these questions. What is there a group life policy? Where are the terms of this policy? So that you and potentially your doctor and maybe an OT or whoever is assisting you can assess, what do we need to do? How do we get this processed? And to assist the individual in getting that documentation in, even if it's a family member who's helping that individual get around and do what needs to be done, so that is in, and they've got the best chance of being able to claim under that. And from the employer perspective, know if you've got these policies in place and what it means to have a policy like this in place. So that if your employees don't understand it or aren't aware, that as soon as something like this happens, it triggers, okay, well, let's sit down with them, let's talk to them, let's explain what they need to do, and let's get this process going. Because the employer, as I understand it, submitting it doesn't mean it's going to be accepted. At the end of the day, it's the insurer that's going to accept it or not.
Oh, absolutely. It's an insurance decision, not an employment decision. So it's up to the life office to make a decision around the validity of the claim and how it's going to be managed and run going forward. So that is one of the things that one of the issues that has come up repeatedly over many years is that employees, for some reason, get the idea that this is a pension if it's an income benefit. And it's not a pension, it's an income benefit, and it gets reassessed regularly. The terms change after a period of time, and it's still going to get reassessed regularly. That's going to continue until age 65 or 63 or 60, whatever the actual contract defines as the end point. And that needs to be clarified too. Quite often, unfortunately, it ends up being an independent occupational therapist who ends up having to explain, occupational therapists who do this work, having to explain this isn't actually a pension and it's not guaranteed, because there's a medical boarding that happened at the employer, and somehow the confusion crept in that because I'm medically boarded, I'm protected with this benefit until age 60, 63, 65. And that isn't actually the situation.
No. And for the employer to understand that there is a reassessment, and perhaps, then once someone is claiming from that disability policy or claiming under it, it doesn't mean it ends there. They may, and that is what it's really there for, is to cover them for the period that they're unable to work. The idea is always to rehabilitate them back into the workplace, right? So you cannot write someone off because they're on this policy, they're claiming under a temporary disability. If they're permanently disabled, well, then it's different. Well, it's slightly different because depending on the terms, right? That policy may stop still paying depending on the definition of disability and whether it's own occupation or all of that. But it's not that's done and dusted, good, that's it.
No, it's not. And when it comes to an assessment of an individual being able to work in any capacity to which they're suited with training, education, experience, etc., or could become suited depending on the terms, it's the insurer that makes a decision. And if the insurer deems the person able to work, the benefit can reduce or stop. And that can happen at any point of the claims process. Obviously, there are cases where people have a disability of such severity that they aren't going to be able to go back to work, and then the benefit will continue. And there are ways that assessors deal with that, so that they just have to submit what we call a certificate of continued disability every year. It's a very simple form, because you know that this is a long-term claim. But in many situations, it's not a long-term claim, and there is this continuous reassessment. And if somebody is well enough to go back to work in an alternative capacity, if the insurer feels on a reasonable basis that this is possible, then the benefit can certainly terminate. And that needs to be understood too. And this is where this confusion about pension and being medically boarded often creeps in.
Yeah, that's very useful to clarify. I know, Mignon, you are going to have to be in court at 10. So because that time's fast approaching, is there anything that you would, before we move over to Q&A, is there anything that you would like employers and employees to know about this process? And from your perspective or from your experience, what will make it easier for a successful outcome?
I think first of all, I like a lot what you said, Elise, around the information being available, what the policies entail, because I've been part of a process often in my neuropsychology practice where, due to cognitive difficulties, someone has had a disability claim, but what people don't really understand the limitations that it will also place on them, that it's just a portion of their income that comes as a shock. It comes as a shock that they're not allowed to work. One of my clients, what was communicated to him is that he cannot even work as a volunteer. So for people to understand, there is a benefit, but it has implications, enormous implications for your life going forward. And just that the information is shared, from whether there is a policy in place to what the policy will entail. And then I wish that HR would lean on people like me to chat about how a specific psychiatric diagnosis will translate into the workplace, what one can expect the difficult issues would be. And I would really invite HR to reach out to a clinical psychologist when there is a particular case and you are not sure how to read the person's behavior. Reach out and ask and chat through a diagnosis, whether it is an autism spectrum diagnosis or PTSD or depression or anxiety. Just chat and educate yourself about the disorder beyond just what is out there on the internet. So you need someone to help you think through, something that Elise and I do a lot in the medico-legal context, to take the client with the diagnosis and the disability and to imagine what the challenges will be in the workplace. How will things go wrong? And if you can imagine that, you will be able to handle the situation better.
And sorry, if I can jump in there as well, and it speaks to the other thing that we were talking about, what I introduced, the term, the cookie cutter approach, is that to reach out. If you've dealt with an issue previously with depression or whatever, understand and reach out to see if it's the same, if it's different, how the treatment should differ, but also importantly, the performance misconduct issues, which we are seeing a lot of. Reach out and find out if what the person is saying they are experiencing or what they've been diagnosed with is going to result in what the employer is seeing in the workplace in the form of misconduct or poor performance. because really that is the idea, is to determine what we're actually dealing with. Just because it presents itself as poor performance or misconduct does not mean it is misconduct or poor performance.
Okay, can I also suggest, I have to dash because it's 10 minutes to court and I've got to
Yes.
walk down.
Thank you so much.
Anybody has a question, pop me an email. And then I want to just mention one thing.
Yes.
Esther Perel is a clinical psychologist practicing in New York, and she's very well known for her podcast on marriage counseling. But she has a wonderful podcast on work relationships. I love listening to them, and I think if you are in HR, you will love listening to them as well. I am going to pop it into the chat box quickly, and Esther, also. Thank you,
and we'll
Mignon.
share it. Thank you so much for
Thank
your
you so
time,
much,
Mignon.
Mignon.
We really appreciate it.
All the
Thanks.
best.
Bye.
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 Bye. I just want to pick up on one contractual aspect of income
Yes,
cover,
Elise.
where because people do sometimes believe that they can't ever go back to work and are sometimes given the kind of information that Mignon mentioned. So in many contracts, again, contract specific, there is a formula called the loss of earnings formula. So if somebody is able to go back to work 4 hours a day and earn a portion of what they earned previously, but they're on a benefit, there's a calculation built into the product that allows them to earn from the earnings from paid by salary and a top up to whatever makes up to the 75%, but actually with a little bit of an incentive bonus, it actually ends up with a little bit more money through this formula on the benefits. So the insurer pays a bit and the employer pays a bit. And that often allows people to be functional in the workplace and get remuneration by working, but not lose out by not being able to earn as much as they did previously because the benefit makes up that difference. And that is often missed in feedback to individuals around how they can maybe reintegrate back into the workplace whilst being on a benefit.
Okay, super. Thanks for highlighting that. So we've got a couple of minutes before the end. And just to ask if there are any questions. I don't see any questions coming through, but let me ask Andrea. Andrea, have you seen anything? It's an opportunity for anyone, if you want to ask any questions with regards to what we've been discussing, please pop them there now so that we can deal with them. Q&A is open. Is it? Any questions?
Well, we've either explained everything really well or we've lost everyone.
Or everyone's left. Let's see. Well, then in the last couple of minutes that we have, if there are no questions, Elise, is there anything based on experience, just on your experience in what over the years in the workplace dealing with incapacity, whether it's because we've spoken a lot about mental health because that's something that's become very topical, but mental health wise or on the physical illness injury side, are there any tips that you'd like to give to employees or employers on how to deal with it better or make it easier for them to deal with it, or anything that you wish people knew? Yeah.
I think the only thing I can highlight, which has really been a big part of our discussion, is really for employees to really communicate. Sometimes there's a bit of a breakdown between management and employee, and maybe a bit of a mediation environment would be better to sort out some issues. That can often get over whatever impasse there is and help people understand. But really it's about communication, being clear with each other, understanding all the requirements from each party. And it is on both sides. There's no one side here. But it is a matter of people coming together with their bit from each side. And then, on the insurance side, understanding the bigger picture. So ideally, if I had a wish for how incapacity is dealt with in the workplace, when we know there's an incapacity issue, it's to understand what the whole picture can look like, how we can all work together in order to make this as smooth a process as possible. And not every situation is going to be one where people can be accommodated, but obviously where that is possible to make that happen. And it's really starting the conversation from day one.
Absolutely. And if I could add from my perspective, it's understanding what you're dealing with. Is it an incapacity issue or is it something else? Is it incapacity presenting as something else? Or is it something else? Because if it's something else, then deal with it as misconduct or poor performance. But if it's incapacity presenting as that, one needs to deal with what it really is, which is the incapacity, right? And to ask, but you don't need to accept that on face value. Ask, engage with doctors, get an opinion as to, is that what's causing it? Or is it a combination? Or is it really just an individual who's saying that they have an issue, but it's actually not the case, right? Because you could still be ill or have a condition which isn't going to influence your work in the way that's presenting itself, if that makes sense.
Yes, no, there can be real non-performance. I mean, we know that this is a real issue. And so that again,
100%.
that comes back to the conversation of, let's have a discussion about what's really going on here, and then take it from there, because sometimes it is maybe non-performance, just non-performance, as opposed to incapacity non-performance.
Yes, yes. But to find out what it is and then deal with it. I think we're all a bit nervous about dealing with the issue and asking what it is, particularly when mental health is involved.
Yes, mental health is a tricky one. I
Yeah.
do accept that. Yes.
Yes, yes. No, absolutely. Thank you very much. I see we don't have any questions. So as you said, I hope we've answered everything. But if not, we've lost the interest of everyone here.
Natasha Feltzman.
Oh, yes.
She's put her hand up. I don't know if that means there's a question.
There is, but Natasha, are you not able to put your question in the Q&A box?
Is there no way of speaking to Natasha? Oh, here it is. It's up there, Justine.
Oh, there it is. Okay. I have a case where an employer has exhausted and moving very closely to yours.
So I can answer
that.
Yes,
by all means. Go ahead.
So you've got an incapacity matter where you've asked the doctor to prescribe adjustment to the working environment, and then nothing has been provided. So the only suggestion I could make would be to I don't know if you've emailed or how you've asked for the information, but doctors get very busy and sometimes things get lost. So maybe picking up the phone, the old-fashioned way of doing things, picking up the phone and actually asking to speak to the psychiatrist might be helpful. You certainly have the right to ask for a report. The psychiatrist will be very careful with the boundaries around confidentiality, so that doesn't have to be worried about. And if all else fails, you could get an independent opinion on this this employee. So you could ask your employee to go for an independent functional capacity evaluation, about how things are, because then that independent person, and this is, I'm speaking with my OT hat on, the independent person will be able to then speak to the psychiatrist, speak to the employer, and pull it all together in terms of, you've asked for work adjustments. That is you're perfectly entitled to do that because it's part of an incapacity management process.
Great. Thanks so much, Elise. Anything else? Any other questions before we sign off? No questions.
Okay.
Brilliant.
Well, there we go.
There we go. Well, thank you very much. First of all, thank you for your time. I know you're
Pleasure,
very
thank you.
busy, and thank you for being open to chatting to us about all of these things. I think it's been very valuable to hear it, and to hear it from someone who has got experience, and practical experience. So thank you for that, and hopefully Mignon got to court in time, and everything's going well there.
So,
And
absolutely.
and
Thank you,
depending-
Justine.
Yes, no, thank you very much, Elise, and thank you to the audience for joining us. I hope it was useful, and you're welcome to provide us with comments on if you found it useful. Perhaps we need to have something else, another one of these, to just help everyone pull everything together so that things run smoothly and correctly in the workplace
And
and
as
managing
Mignon,
risk.
and as Mignon said, same with me. If anybody wants to bounce an idea or ask an opinion about how to manage an incapacity issue, please, I'm available. You'll find me on the internet. I'm available.
Yeah, brilliant. Thank you. And we'll share your details as well, so that anyone, if they need to reach you, and send out your telephone number, don't worry, but your contact on email and all of that, we'll share those and we'll take it from there. Thank you very much. Thank
Have
you.
a good
Keep
day.
well.
Thanks so
You
much,
too.
everyone.
Bye.
Bye.